Hello, time for another Man in Gray book review. December 15th is National Bill of Rights Day in the United States, so I thought it would be appropriate to review a book about the Bill of Rights. This book is called The Bill of Rights and Writing That Formed Its Foundation. It was published in 2008 by Applewood Books, and it's part of their Books of American Wisdom series. This book contains the text of the U.S. Bill of Rights. It contains a speech given by James Madison to the House of Representatives in which he proposed the Bill of Rights. It contains the text of the Virginia Declaration of Rights, which was adopted by Virginia in 1776 and was one of the source documents for the Bill of Rights. And then finally, it contains a chapter from the Federalist Papers, which was originally a group of newspaper articles written by James Madison and Alexander Hamilton and some others, proposing the idea of a constitution. And this is Federalist number 10. And in that chapter, Madison argues that a functioning democracy has to have protections for individual rights and the rights of minority opinions against the tyranny of the majority. So, a little background here. When the Constitution was being debated, there were two factions, and they became known as the Federalist and the Anti-Federalist. The Federalist people argued that the existing U.S. government, the Articles of Confederation, was not working. It was inefficient and basically not able to raise taxes properly and so forth. And they proposed scrapping it and coming up with a new system of government, which would have a much stronger central government with a president and a Congress and so forth. The Anti-Federalists were very fearful of this. They thought that whatever the flaws of the Articles of Confederation, it worked well enough and it protected individual rights. And they were very fearful of a strong central government. A strong central government might turn into dictatorship or monarchy like they had just fought to escape from England. And so eventually the Federalists won out and the Constitution was adopted. But even after the Constitution was adopted, there were complaints that the Constitution didn't spell out individual rights, and that there was a fear that the president or Congress could then usurp individual freedom. And so to assuage these fears and doubts, James Madison, working with other members of the House of Representatives, came up with a list of 10 amendments to the Constitution, spelling out individual specific rights. And these became known as the Bill of Rights. And they were eventually voted on by Congress and then adopted by the states in 1791. And so that became part of foundation law for the United States. Now, I've jotted down here a summary of the 10 amendments because a lot of people it's been years since they've studied the Bill of Rights in classes. And so they may not be familiar with some of them. Some of the amendments, if you're an American, some of the amendments are quite familiar, but a lot of them are not. So I'm going to quickly roll through here and summarize the different amendments here, which are, of course, spelled out specifically in this book. The First Amendment is probably the best known of all the amendments in the Bill of Rights. First Amendment guarantees freedom of speech, freedom of religion, freedom of the press, freedom to peaceably assemble, and freedom to petition the government for if the government has done something to harm you, you have a right to petition the government to stop that. The Second Amendment is also very well known. It's the amendment that guarantees the right to bear arms, the right to own firearms. The Third Amendment is one that protects people from what was called quartering. In other words, quartering was when the government could force individuals to house soldiers in their private homes. And this was done extensively by the British during the Revolutionary War. And so after the war, this amendment was put in to prevent that. So the military cannot put individual soldiers in private homes. But that's never really come up. It's the one amendment, as far as I know, it's the only one of these 10 amendments that's never involved a lawsuit because the government has never done this. It's never quartered anyone. Number 4 involves searches. Amendment number 4 bans unreasonable searches and seizures. It also says that any search warrants have to have probable cause. But it doesn't say what unreasonable is, and it doesn't say what probable cause is. It leaves that up to courts to decide. And there have been, excuse me, there have been a number of court cases over the years involving various searches. One of the most interesting was about 15 years ago, where or maybe it was 20 years ago, where some police searched garbage bags and found drug paraphernalia and used that to get a warrant to search a guy's house, and he was arrested for drug dealing. And he argued that the searching of the garbage was an unreasonable search. And the courts ruled that garbage is if you put garbage out on a sidewalk or in a dumpster, it no longer belongs to you. It belongs to the public. And so it wasn't an unreasonable search. So courts have to decide what's reasonable and what's unreasonable and what's probable cause. The Fifth Amendment is another amendment that's very well known. This is the one that protects individuals from being forced to testify against themselves. That's known as self-incrimination. It also protects individuals from being tried twice for the same crime. That's known as double jeopardy. It requires due process, so you can't just be locked up without going through a legal process. And if you're indicted, you have to be indicted by a grand jury. And if your property is seized by the government by a process called eminent domain, you have to be compensated in a fair way. So if government seizes your land to build a highway or something, you have to be paid market value for that. The Sixth Amendment involves trials. It requires a speedy trial in public. You can't have secret trials. You have to be tried by a jury. You have to be informed of your charges. You can't just be arrested and not told what the charges are. You have a right to confront a witness, all witnesses, your accuser, and any witnesses. You have a right to personally confront them. This is why, in a lot of cases, women who have been raped have not filed charges because they don't want to face their accuser. But your accuser has a right under the Constitution to face your accuser, no matter what the crime is. And you also have right to confront your accuser. Okay. The Seventh Amendment is one that's not carried out very often, or not litigated very often. It requires a jury trial in civil cases. In a federal civil case, you're required to have a jury trial if the amount being disputed is over $20, which, in the 1790s, $20 was a lot of money. So basically, any federal civil case has to be tried before a jury. And it also says that a judge can't overrule the finding of facts by a jury. So if a jury determines that something was true, the judge can't just say, well, they were wrong, and throw it out. The Eighth Amendment involves punishment. It says you can't have cruel or unusual punishment. So various forms of punishment have been banned under that. And it also says you can't have excessive bail or fines. Again, the British, during their time ruling the American colonies, would sometimes throw people in jail and have such excessive bail that nobody could possibly pay it. So they basically just rotted in jail. The speedy trial provision in the other amendment was the same thing. The British were known to just lock people up and never bring them up for trial, so it does that. The Ninth Amendment says that individuals have other rights that are not mentioned in the Constitution. In other words, the Constitution or the Bill of Rights doesn't necessarily list all rights that you have. You may have rights that are not listed in the Constitution. And in the mid-20th century, the Supreme Court made a number of rulings about this involving the Ninth Amendment, saying that Americans have a right to personal privacy. Now, it's not spelled out in the Constitution, but it's one of those implied rights. Now, this is a real debate among factions of the Supreme Court today. The conservatives, the strict constructionists say that you don't have a right to privacy because it's not spelled out in the Constitution. But those who argue for a right to privacy say that the Ninth Amendment says that you have rights that are not specifically spelled out, and it should be obvious in a democracy that you have rights to privacy. This right to privacy was used in a Supreme Court ruling to overturn a law that banned. There was a law in a specific state that banned the purchase of contraceptives, and so that law was thrown out, saying that it violated the right to privacy. And of course, the famous Roe v. Wade ruling on abortion was based on the right to privacy as well. So that goes back to the Ninth Amendment. Finally, the 10th Amendment is the States' Rights Amendment. It says that any rights that are not specifically guaranteed to the federal government in the Constitution are prohibited from the states by the Constitution are the rights of the states. In other words, anything that's not in the Constitution is the state's purview. So the states have the right to set up elections, run elections, to set up schools, and build highways, and so forth. So any right that's not given in the Constitution to the federal government devolves to the states. So those are the 10 amendments to the Constitution. Again, ratified in 1791 to reassure people that the constitutional system was going to protect people's rights. Now, of course, as you read through this book, you can't help but be struck by the great irony of all of this, the elephant in the room, as it were, because when the Bill of Rights was being debated and voted on, the majority of Americans didn't have any of the rights that were listed here. If you were a slave, if you were Native American, or if you were a woman, you didn't have any of these rights. You didn't have a right to a trial or anything like that, or free speech or any of this stuff. The whole history of the United States since this time has been an attempt to live up to this. The Bill of Rights was more an aspirational document than one that reflected reality. And so in the 200-odd years since, there's been a slow, very slow rolling out of rights to other people. Slaves, to when women didn't get the right to vote until 1920. So it's been a long, slow process to gradually expand the rights. Now, of course, the other thing I should mention before I close here is that almost every one of these amendments has restrictions on it. There is no absolute amendment, I suppose, except maybe for the Third Amendment, no quartering. There's really either you quarter people or you don't in private homes. But for example, the First Amendment has restrictions on it. The Supreme Court has ruled over the years that you don't have the First Amendment doesn't give you the right to libel or slander people, to make false advertising claims, to reveal national security secrets, to sell child pornography, things like that. Those are all not considered First Amendment rights. The Second Amendment gives people the right to bear arms, own firearms, but doesn't give you the right to own mortars and cannons and types of machine guns and high explosives and things like that. So there are restrictions on almost all of these. The right to protection against unreasonable searches and seizures. The courts have ruled that students in minors in high school and elementary and middle schools don't have the same rights that adults do. School officials can search backpacks or lockers or even a student's body if they have a reasonable suspicion, not that a crime is being committed, but that a school regulation is being violated. So students don't have the same rights against search and seizure that others do. And even though you have a right to jury trial, minors do not have a right to a jury trial. Minors are usually tried in front of a judge, not in front of a jury. So there are restrictions to the Bill of Rights. And as I said, it's more of an aspirational document, although as time has gone on, the rights have become more and more spelled out and enforced for all people. So if you are at all interested in the history of our government and the rights that you have, this is certainly an excellent book to read. It's only less than 60 pages, but these contain the core documents that guarantee the rights that we're supposed to have as American citizens. The book is The Bill of Rights and Writings That Formed Its Foundation, published by Applewood Books. This has been another Man in Gray book review. Thanks for watching.